Let us look on the law that deals with impeachment, and we explain it. Under Article 75 of the Kenyan Constitution, conduct of state officers. This is the punishment provided for whoever is found guilty to have abused or to have lived below the chapter 6. It says, a person who has been dismissed or otherwise removed from office for a contravention of the provision specified in clause 2 is disqualified from holding any state office. When you read this, Rigathi was a state officer as a deputy head of state. He was removed by impeachment. And therefore, if you read 75(3), Rigathi will not be in the ballot. But the proviso in that is, was Rigathi removed pursuant to clause 2 of section 75? What does section 75(2) say? A person who contravenes clause 1 or article 76, 77, or 78 shall be subject to the applicable disciplinary procedure for the relevant office, and B, may in accordance with the disciplinary procedure referred to in paragraph A, be dismissed or otherwise removed from office. Does impeachment fall under disciplinary processes? Wakili Dan Sanomari finds that this does not fall under disciplinary processes. Section 76, Article 76 deals with those who are employed and appointed into public office. These are judges, they are appointed, these are directors, these are officers in public service, in state corporations, in parastatals, not elected people. Rigathi is an elected office. The deputy president's office does not fall under this, and that is why I am saying it will not be right to say Rigathi will be barred from this question. So this question about those who are elected was dealt with under the same case. Rigathi, the position of deputy president, was an elected position. In the same petition, petition 552, there was the case of the Honorable James Ondicho Gesami, who was the member of parliament from West Mogrango constituency. Sorry, I have got to disclose, I am a member. I come from West Mogrango constituency. The member of parliament that time, he was taken to court for having misappropriated CDF funds. Gesami admitted that he took CDF funds and into his personal account, and he accepted that he will refund that money. In paragraph 26, the fourth petitioner cited several provisions of the Constitution in support of his claim, including Article 10(2), 73(1)(a), and 73(2), which address questions of national values, leadership, and integrity. The third petitioner averts that the fifth respondent has, in the course of exercising public duty, engaged in corrupt activities and misuse of public office, where he transferred Kenya shillings 1,050,000 to his personal account from the CDF account. He further averts that the fifth respondent, that is Honorable James Ondicho Gesami, by an order of the High Court, was compelled by a writ of mandamus to refund the monies he had unlawfully withdrawn from the CDF account for his personal usage. Paragraph 27, which is very critical in this judgment. The fourth petitioner further contends that the fifth respondent, that is Honorable Gesami, ultimately refunded the said funds after due court process. In view of the fourth petitioner, this constitutes a breach of trust, thus deserving the disqualification of the fifth respondent from vying for elective or being appointed to state office. So, my member of parliament that time was the people went to court saying that because he had been ordered to refund money he took from CDF, he cannot contest for the seat any elective position in that matter. What did the judges go by? This is the answer, and this is the shocker. The judges went and looked at Article 99 of the Constitution. What does Article 99(2) say? A person is not disqualified under Clause 2 unless all possibility of appeal or a review of the relevant sentence or decision has been exhausted. A person is not disqualified under Clause 2. Let us look at Clause 2. What does Clause 2 say? It says, a person is disqualified from being elected as a member of parliament, as a member of senate, as a president, as anybody in elective posts, if he is found in accordance with any law to have misused or abused a state office or public office, or in any way to have contravened Chapter 6. Gachagua was impeached because he was found by Parliament and by the Senate that he had impeached, he had abused his office. He was impeached. Gesami, the member of parliament, was found to have contravened that section, but he had filed an appeal. What did the court found? The courts allowed Gesami to be in the ballot. Gesami today contested, he won the seat in 2013. Gesami, he's currently the deputy governor elected by the people of Nyamira, sitting as the deputy county governor of Nyamira. So, will Rigathi be stopped? Rigathi will not be stopped, because under Article 99, even if the three judges find that the procedure for removal of Rigathi from the deputy president was proper, Rigathi can still appeal to the Court of Appeal. Rigathi can still appeal to the position of the Supreme Court. There are two layers. Remember, the first layer, the High Court, the three judges, that decision has not come out. And whether the decision comes that Rigathi was removed properly, Rigathi will file an appeal to the Court of Appeal. Whether the Court of Appeal makes a decision before 2027, Rigathi will file an appeal to the Supreme Court of Kenya. The only person whose determination has now been dealt with conclusively is Mike Sonko, the governor of Nairobi. He challenged the appeal at the Court of Appeal. He challenged the decision at the High Court. He lost. He challenged the decision at the Court of Appeal. He lost. He challenged the decision at the Supreme Court. He lost. Remember, he went back. He went back to the East African Court of Justice. And the East African Court of Justice found out that the Supreme Court did not give Sonko a fair hearing. Mike Mike Sonko has filed an application for review at the Supreme Court. So the avenues of appeal are not exhausted. What is the lessons behind this matter? No elected person is likely not to be in the ballot. All of them, whether those convicted, remember, the MP for Sirisia, Waluke, was convicted at the lower court. He went, challenged at the high court, he lost. He went to the Court of Appeal, his appeal is going on, he will still be in the ballot. People have always blamed IEBC that they should not clear people with criminal cases. IEBC has no jurisdiction to stop anybody from contesting an elected office. An elected office is different from an appointative office. So whether anybody is arrested and charged and convicted, but he has appealed, he'll be in the ballot for the MCA seat. Whether anybody, you hate him, you don't like him, you call him a thief, he will be in the ballot for the MP seat. Whether you don't like anybody. So what are we saying? President Ruto is going to face all the contestants who will qualify. And what is the qualification? Anybody who is to be a presidential presidential candidate is you are 35 years old and you are a registered voter. That is all. Wakili Dan Sanumari will not be in the ballot. That one I assure you. I'll not be in the ballot for the presidential seat. But anybody is going to be in the ballot. What is the law saying? The law is saying the people have the right to choose who their leader is. In the year 1992, the contest in the first multi-party election, the first multi-party election of 1992, there was the late President Matiba, the President Moi was contesting. Then there was Ford, the party Ford, led by Jaramogi Oginga Odinga. There was the DP party, led by the late President Mwai Kibaki. And then Matiba stood up and split Ford and brought Ford Asili. And the question was, why is Matiba contesting? People said Matiba is spoiling for Jaramogi Raila Odinga. Matiba said, let the people decide. Let the people decide. That was the mantra. That was the slogan. And in 1992, the people decided. Three opposition presidential candidates, Matiba, Kibaki, and Jaramogi, had more votes cumulatively. President Moi had the minimum votes, but he had the majority votes. He was declared the president of the Republic of Kenya. 2027, the courts and IEBC will not stop Rigathi. Nobody will be stopped. The people will decide. The majority, 50+1, will decide who their presidential candidate will be. Is Mike Sonko coming back as the governor candidate for Nairobi? If he presents his papers, yes. May the people, let the people decide. Is Rigathi going to be in the ballot? Yes. Let the people decide who is going to be there. Is Kidero going to be in the ballot? Yes. Let the people decide who they will want, whether it's Governor Wanga or is Governor Kidero. Will everybody who has a criminal case, will the babus, will all of them be in the ballot? Yes, everybody will be in the ballot. Let the people decide. That is Article 99 of the Constitution of Kenya. Wakili Dan Stanomari always bringing it the way it is. But one thing in certain, Wakili Dan Stanomari will not be in the ballot. But I'll not be in the ballot because the law prohibits me, but I will be loyal to Court Helicopter to bring to you controversial positions of the law. Keep watching and enjoy your weekend.